March 4th was a great day for the average American. The Wyeth case involved a patient who received an anti-nausea drug through an IV drip, and a musician who received the IV drip anti-nausea drug wound up getting an infection and eventually an amputation as a result of how the drug was administered. The case was brought in front of the Vermont court, and the Vermont court ruled that it was a failure to warn and that the patient should receive compensation. Wyeth said that you can't make us comply with a state court ruling that is stricter than the federal agency's ruling that approved the drug. The Supreme Court said that in balancing interests of a question of the Food and Drug Administration's approval and state court failure to warn, that the federal ruling does not preempt or take precedent over the state court standard. You have to understand that the Bush administration was anti-consumer and pro-big business, and used very, very wisely, very carefully and very craftily the idea of preemption to try to protect big business. They said, we want to put big business in a better position than individual consumers. And the U.S. Supreme Court is saying, we're leveling the playing field. Safety comes number one, and we're not going to allow large pharmaceuticals to hide behind these rulings. If the court had ruled in Wyeth's favor, then the area of preemption would have been supreme, meaning that if the federal regulations, if the Food and Drug Administration or an agency, or even worse, an executive order, said that something is a standard, then state courts could not look behind it, and safety of consumers would have been placed in a secondary position as compared to the ability of large pharmaceuticals of lobbying the federal government.